Welcome back to the WHHI. News history is being made with the former president being tried in a criminal case. We're going to take a look at how jury selection was done. A lot of people are wondering about that. And to help us do that is Duffie Stoner, 14th Circuit Solicitor. Good to see you.
Alec, thanks for having me.
Okay, we've got 12 jurors, 6 alternates.
Right.
What did you observe that would be different there from here?
Well, in any criminal trial, and I think everybody needs to understand that in every criminal trial, it's going to be conducted as that jurisdiction requires. That if it's in federal court, it's going to be done a certain way. If it's in state court, then you break into 50 different states, and all 50 states are going to have different rules on that. So some of what they did was consistent with South Carolina law. Some of it was something we don't see on a regular basis. So you're correct. They selected 12 jurors, which is consistent with South Carolina law and probably every jurisdiction in the country. Having the 6 alternates, that's generally up to the judge determining how long they think the case is going to last, any likelihood that there's going to be problems with jurors going on. So that's consistent. That's not particularly unusual. The questioning that went on in this is probably the biggest difference. And I think you see that in the time it took. It took 4 days for them to pick a jury. That's extremely unusual in South Carolina. It usually takes us about 3 hours to select a jury. Yeah.
So you wouldn't say it's just because of who is on trial?
No, I think I would suspect that a jury in New York, a selection of a jury in New York is going to take a number of days regardless.
Okay.
Now it may be, obviously you're dealing with a former president, so maybe that is an extenuating circumstance, but generally I think it's going to take longer because of this. The questions that are asked the jurors are all questions seeking to uncover some type of bias. Those questions can come in the form of a questionnaire, which is sent usually by the clerk to the individual juror before they're even brought to the courthouse. That's consistent with federal law. That's consistent with a lot of states. South Carolina, we send a questionnaire. It's not quite as detailed.
In advance. Okay.
In advance. The judge asking questions of the jurors, that's consistent as well. That's going to happen in federal court. It's going to happen in New York. It's going to happen in South Carolina. Here's what's different. In South Carolina, unless it is a death penalty case, the lawyers, neither the prosecution nor the defense attorneys can ask jurors individual questions.
Is that unique, though, to South Carolina? Does that happen in other states?
I think it is. It is not. We're probably not the only state, but we are we are a part of the minority on that. I mean, I think most states allow for individual questioning by lawyers in criminal cases as well as civil cases, and that's going to take a lot longer because now you sort of bring that adversarial process into the selection of the jury. You're going to have, in some ways, both lawyers trying to sort of give their opening statement, so to speak, to the jurors and see how they react to it. So that's going to change it. And I think that's why you see a jury process in New York that takes 4 days instead of what would take literally 3 hours in our state.
In the questions that are submitted prior, are those crafted by both the prosecutor, defense, and the judge? Who puts those together for the potential jurors?
There are some basic questions that every juror is going to be asked in every type of question, in every case. In other words, do you know anything about this case? Have you heard about it? Right. Have you read about it? Have you anything on social media? And then the question behind all of that is can you set aside anything that you know or that you've heard prior to coming into this courtroom and make your decision based on the facts and evidence that you get in the courtroom from the witness stand.
And that's critical, and that was asked in New York,
right? It's going to be asked in every jurisdiction.
Because as someone said, you would not, you'd have to have your head, buried in the sand if you didn't know Donald Trump.
And that's not what you want. I mean, you want jurors who are concerned about the community and know what's going on. I don't think you want a jury that is totally absent of any community knowledge. Yeah. And so the knowledge itself is not the key. The key is, can you be fair and impartial? Can you set everything aside? And that's where the more extensive questioning comes in, and that's what I think you've seen in this case.
As you being a prosecutor, do you wish you had the ability to question potential jurors?
It's a tough call. I think that the idea, you look at the second part of this, which is something that you're going to see now. They're projecting this case is going to last 4 weeks. We tried 3 cases, 2 murders and a rape case this summer, and it took us less than a week each time to try those cases, and one was in the middle of a hurricane. I don't know that you can, I don't know that it's that it's fair to the victim. I don't know that it's fair to the community to have a case that lasts that long if you don't have to.
Okay. Duffie Stone, we're already out of time, but I appreciate your perspective. Thanks for joining us.
Thank you for having me.
And we will be right back.